The last case to come before the court today is Headley versus Marincek. How do you pronounce that?
Marincek.
Marincek. Okay. The appellant and appellee both will have 15 minutes to present their arguments, but the appellant may reserve up to 5. Are we ready to listen?
Thank you.
I know you've been here many times, so you can probably give me the drill, but you can reserve up to 5 minutes if you want.
Thank you. I would like to reserve 5 minutes, and this will be the first time I'll be arguing for YouTube since I've
Oh, that's
been in
right.
procedure.
I forget it's there because it's not pointed toward me. That's another.
I almost changed my mind and let Mr. Whitaker argue, and I remember that was there. I would, Your Honor, like to reserve 5 minutes for rebuttal, please.
That's fine.
Thank you. Good afternoon, Your Honors. My name is Andrea Whitaker. I'm appearing today for the appellant, Mr. Robert Headley, along with my co-counsel, Mr. Whitaker. I'd like to begin by just noting the situation that we find ourselves in here today, and that is that the trial court took the extraordinary step here of setting aside a jury's unanimous verdict for fraud, despite the fact that no one challenged the jury's determination of fraud, the finding of fraud, separate and apart from the breach of contract finding, and the finding of malicious conduct necessary for the jury to award the punitive damages that it did. In fact, in denying appellee's actual motion for a directed verdict on both the fraud, count 2, and on the punitive damages, the trial court specifically stated that there was evidence supporting both of those counts for the jury to make a finding for the plaintiff and deny it.
Is that the end of the inquiry, though? There may have been evidence to support both of them going to the jury. That doesn't mean there's necessarily separate damages, does it?
Well, I think, Your Honor, that there's two separate issues here. And I think that what the court's moving to now is the issue of the economic loss rule. And I think that the first thing to consider is that it simply just does not apply to intentional torts. The economic loss rule, as originally stated by Chemtrol, the Ohio Supreme Court case that we cited, talks about that economic losses premised on tort liability for strict liability or negligence simply are not allowed. And in other words, that is, you can't have a tort cause of action based on a breach of contract. There's nothing wrong with economic damages, even purely economic damages, coming from a tort action. You have tortious interference of contract, fraud in the inducement. Those are all purely economic damages. So I think that the important inquiry here is whether or not there is a separate duty, separate conduct here. And I think that the evidence is clear that it was alleged separately. This was never pled in the alternative, as indicated by appellee. These were alleged separately and proven separately by the evidence. And I think that while it's clear that this is about, that the economic loss rule is about negligence supporting a tort liability, there isn't a lot of Ohio case law on it. So there's the Isolt case that we cited to the court that talks about that fact, that it doesn't apply to a tort cause of action. And it relied upon several federal court cases as well. And I think particularly instructive is the In Re Updegraff case. And that is a specific finding that fraud and contract cases involve duties that are separate and apart from each other, and therefore can have separate claims. And I think that's very consistent actually with the purpose of the rule. And that is that you can't have a tort recovery for the same thing. You can't have a tort recovery for simply not paying your contract. But if this law is read the way that appellee argues, there's absolutely no deterrent for every person entering into a contract to do exactly what the appellee did here. And that is lie, make misrepresentations, engage in fraudulent contract, and then just take the chance. If they end up having to pay the contract, they'll never have to pay more than the breach of contract claim. So why not enter every contract, never intending to pay, and then just take the chance that you're going to have to pay the contract because you're not in a worse position. And I think that kind of extrapolation, where the argument, if you follow the appellee's logic, leads, shows that the idea that a tort liability is allowable when it is a separate duty, separate conduct, as the cases we cited indicate.
There are obviously other consequences and damages, so to speak, for like you said, entering into a contract with never ever intending to perform under the contract or to pay or whatever. You have pre-judgment interest, post-judgment interest, you have different ways of compensating for that, don't you?
Well, there are different, well, first of all, I think that the damages issue, although raised by Appellee, I think that if the issue comes down to simply that there aren't separate damages, first of all, I'll talk to the court briefly about why we believe that there are separate damages here. But if in fact the court recognizes that an individual can go forward in a tort case and a breach of contract case, then the individual should be given the opportunity to choose which count they want to go forward on. This isn't a case where he cannot go forward on a tort case because there's no tort conduct alleged. This is the case where there's conduct alleged that would support a breach of contract and conduct that alleged that separately supports a fraud claim, a tort claim, and that's separate conduct that supports that. And so I think that if the issue is just damages, then at a minimum, the remedy was not to vacate count 2, but to have allowed Mr. Whitaker to choose which count he wanted the jury to go forward on, or to allow Mr. Whitaker to choose which count he wanted the court to enter judgment on. That's not what the court did here. The court relied upon the idea that he simply could not go forward on the breach of contract and the tort claim. And I think that that's an inaccurate statement of the law as stated by the Ohio Supreme Court as well as the cases that we cited in here. I think that in terms of the court's inquiry on damages, there is here separate conduct and separate damages. The conduct underlying the fraud is both never intending to pay for the services, but it's also the fraudulent conduct of acting like he was going to buy the airplane. And Mr. Headley did many things based upon and has many damages based upon that conduct. He waited 8 months to try to collect for the services based on the fraudulent belief that he was going to pay for it, that he was interested in buying the airplane. He spent hours waiting one time to meet with Mr. Marincek based on that fraudulent conduct. And the jury heard all of this.
Well, did he testify as to missed opportunities to sell the plane, or how much he gets paid per hour at a time he was sitting there waiting for him, any of those type things?
No, but I think that a missed opportunity to sell the airplane is more along the line of a missed opportunity as a breach of contract damage. What we have here is the jury heard what Mr. Marincek's fraudulent conduct caused Mr. Headley to do. And we don't have a runaway jury here. We have a $10,800 verdict on count 1, which is the amount of the contract. And we have a separate, very reasonable $5,000 verdict on the fraud count. The jury heard the conduct of Mr. Marincek. It thought that it was fraudulent, and it heard what that conduct caused Mr. Headley to do, the time it spent Mr. Headley, what he had to engage in, and it awarded him a reasonable $5,000 based on what it heard and its perception of the witnesses. I mean, it heard from Mr. Headley, it heard from Mr. Marincek, and that's the determination it did. And it didn't come back with a $200,000 punitive damages. Again, it listened to the evidence and came back with a reasonable verdict based on what it heard. And then I think the fact that we have separate damages from the verdicts of the count 1 and count 2 also evidences that the jury found separate damages here. It did not simply award the $10,000 for count 1 and the $10,000 for count 2. It listened to the evidence. It saw the fraudulent conduct of Mr. Marincek. It saw what harm that caused Mr. Headley, what he had to do because of that, and awarded the damages appropriate to the facts it heard. And again, these are facts that the court found sufficient to go to verdict.
Well, I'm still trying to wrestle with this a little bit. So what were the damages that flowed from the fraud?
Well, I think that there are several damages that flow from the fraud. Certainly, the damage that flows from the fraud is all of Mr. Headley's the time spent thinking he was going to sell the airplane, the time spent, I think he waited 3 hours, he testified at one point, to wait for Mr. Marincek to bring him a check, which Mr. Marincek testified on the stand he never intended to do. He said, I never was going to pay for that airplane. I was never going to pay for those services. I think that the time he spent with Mr. Marincek and his financial advisor, I mean, there were many things that Mr. Marincek's fraudulent conduct caused to happen that are separate apart than simply the failure to pay for the services. I know I'm getting...
You only have about 20 seconds before you're into your rebuttal time. I'll give you the warning there.
Okay, thank you, I appreciate that. I would like to just note that even if the economic damages rule does apply here, which we certainly don't think that it does, I think that it's very clear that it doesn't apply to an intentional tort, which there is evidence of. The trial court failed to consider the issue of attorney's fees. The jury's finding on the punitive damages, it evidences that there was enough here to bring this case outside the American rule. And so we think that attorney's fees were warranted regardless of whether or not the fraud count could go forward. And finally, I would just like to note that I don't think that the courts have the ability to enter a judgment notwithstanding the verdict. That wasn't what was moved for by the appellee, and certainly the basis of its motion upon which the rules require that the motion be entered were not what was moved for by the appellee. So I think that the ruling procedurally was also incorrect and wasn't available to the trial court. Thank you.
Thank you.
May it please the court, John Christie on behalf of Saul Hall and Scott Marincek. I think counsel alluded to it in some of the questions hit on it. This is a breach of contract case. All of the conduct, and nobody disputes this, between Mr. Marincek and the plaintiff in this case was the same. The same conduct led to the breach as the alleged fraud. Mr. Marincek didn't do anything different. There's not any allegations that he did anything different, and there's absolutely nothing that was presented to the jury by way of damages exceeding the $10,000 verdict on the breach of contract. There's a single invoice, not even made to the plaintiff. That's what the jury relied on. That's why they had a very specific number on damages. That's the only thing that was presented.
Did you object to that?
We did, and we moved to direct out the case on that issue.
Okay, but you were alleging in your brief that that both sides had an agreement in regard to what, so I'm a little confused.
Yes, with respect, the jury found that the sides had an agreement. Our position is there was not an oral contract. However, the jury disagreed with us.
No, I'm talking about the agreement of what would go to the jury.
In terms of what issues would go to the jury? Yeah, at the end of the day, I believe they can present whatever they want to the jury. They just can't recover more than once for the same conduct.
Well, I was just confused because you said you'd objected to it going to the jury, and then I thought you said you had an agreement that they could recover for it.
Correct. I think they're only entitled to the single recovery. And I apologize if I was unclear.
That's okay. We'll go through the record with a fine-tooth comb, don't worry.
Certainly. You know, I think the Floorcraft case that we cited controls the issue with respect to economic loss. There was nothing taken from the plaintiff in this case. The plaintiff spent time just like everybody else spends time on things. And he was paid for it under the oral contract that was found by the jury.
So your position is it's not a fraud, and aside from the damage issue, that if somebody enters into a contract with no intent of ever performing, that's nothing more than a strict breach of contract.
I think it's still a strict breach of contract. I think otherwise you open the floodgates to every single collections suit giving rise to claims of fraud and punitive damages and attorney fees on the guy who doesn't pay his cable bill, the guy who doesn't pay his credit card bill. You know, I went out and bought a $5,000 big screen TV knowing that I don't have any source of income. Have I committed fraud, or have I breached my contract to American Express? I think I breached my contract to American Express. I don't believe that that's fraud, but certainly I don't think American Express is entitled to their attorney fees and a punitive finding against me as well. They're entitled to the interest. And in that instance, the contractual interest that was negotiated, here we don't even have that. We've got an oral agreement between the parties. There's no doubt, and the evidence is very clear, the only damages that were presented over the course of this trial was the cost of the flight. There were receipts submitted for food that was purchased. There were receipts submitted for gasoline and airport fees that were submitted, and the total amounted to, I believe, $10,280. That's the only evidence that was submitted. That's the only thing that the jury had to rely on. And everybody agrees that all of the conduct is the same regardless of which cause of action a jury is addressing. It is a legal issue that was properly determined by the trial court. I believe that the plaintiff could present as many claims as he so chose. But I think the law is equally clear that the plaintiff can only recover one time for the damages that he suffered. And since he didn't present any damages beyond the $10,280, he can't recover anything beyond those damages. And ultimately, that's what the trial court determined, and that's what the trial court did. So he has been made whole by the verdict. He has been made whole by the result, and he's getting paid for the contract that he went after. Had he chosen to instead withdraw that and say, no, I want the fraud, he could have still gotten the $10,280.
But there are different elements that are applied on each count.
Absolutely.
And the tort count, the fraud count, requires intent.
Absolutely.
What you're stating was that it's not fraud to buy something with no intent to pay for it.
What I'm stating is that when you sue on the contract claim and you pursue that, you limit yourself in terms of the type of recovery that you can get because you have pursued the contract claim. Had he chosen to not pursue the contract and instead chosen to pursue the fraud claim, then we have a different case. But I do not believe you can pursue both of them and expect to recover on both of them, which is essentially what they're asking. Counsel today said it, and the record shows it.
But you have potential for punitive damages on a fraud claim. Now, I don't know the history of this case.
Certainly.
But you're saying you can't plead both and then elect your remedy?
No, I'm saying that you absolutely can. You absolutely can plead both. The risk that you run is, should you prevail on the contract claim, I think Floorcraft tells us that you necessarily cannot, at that point, continue to pursue the fraud claim and cannot receive a judgment on the fraud claim. Had there been an inquiry or a request to break out things different, to have a jury interrogatory finding something different, what have you, then I think we have then you have an issue. But that request was never made by the plaintiff. The plaintiff said, and there were discussions on and off the record, and I know off the record doesn't matter, on this issue, and the trial court and myself both expressed concerns about the conflicting nature of these two counts.
So what jury instructions were there?
I believe there were jury instructions that were provided on both.
Did they plead in the alternative?
Well, they say in their brief that they did not. I think when you have two separate counts that are based on the same thing, I think by definition they have pled in the alternative. There was an objection to the fraud and to the fraud instructions because I didn't believe that was proven and that was appropriate, and we had lengthy discussions on those issues because of just the reason that we're here. The issue is, when the determination was made to go forward on the contract claim and submit that to the jury, the recovery is then limited. Floorcraft tells us that. That's the seminal controlling case, and they haven't cited any case law that says Floorcraft is wrong. They've just said, we want to create something new to set aside Floorcraft in a collections lawsuit so that every collections firm can now go after somebody for fraud too. That's not what the law says, and that's not what Floorcraft tells us the law says. But they want to set Floorcraft aside with respect to these issues when they had the decision. They had the right to go and pursue a fraud claim. They had the right to do that. and they have the right to present it to a jury, but the problem is that they created a situation by the way they chose to present their case where they have what appears to be either a double recovery and or a conflicting recovery, because at the end of the day, regardless of all the rest of this stuff, and you can interpret the case law and Floorcraft, as I believe it's pretty clear, or you can disagree with me, but at the end of the day, on the fraud, there is no damages that were presented above and beyond those damages that were awarded relative to count one, the contract claim. There's none.
Is that subject to a cross appeal?
It is not.
I know that what happened,
Yeah.
but I'm just saying, wouldn't that be the subject of a cross appeal though? Because right now what we have is a jury saying there are damages, whether there is or isn't, right?
Well, what we have is the court setting that aside and properly adjusting the verdict.
Right, but,
So I don't believe that they're standing to question an appeal, to question a result that isn't a final appealable order. As soon as the court made its rulings,
as soon as it granted the J and a B.
correct, as soon as that happens, the fraud
Goes out the
is
door.
gone, so there's nothing to appeal with respect to that issue.
Okay.
On behalf of my client.
No, I get you, I understand what you're saying. Okay, so now then, back to that J and B.
Certainly.
How did that come about? I understand you filed a motion for a directed verdict.
Correct.
But why did you file a motion for a directed verdict?
Because it was mislabeled as a directed verdict. It's a JNOV, however, it's characterized and.
No, I'm not trying to embarrass you.
Should
I'm
it?
trying
Certainly.
to figure out, did the judge, I mean, is there on the record what happened with that?
What is on the record is the parties discussing the issue as to how it's going to be submitted to the jury. After the result came in, I believe, off the record, the judge acknowledged to counsel that this was the concern he had going in, and that he thought that both sides should brief the issue so that it could be more properly dealt with and the record would be clear. That's what we did, and the court looked at that information and made its ruling based on that information. I mean, candidly, I think that the arguments set forth are pretty similar to arguments that were made at the close of evidence. Certainly, there was more case law and more research that went into the filing of the brief than had taken place at the conclusion of the evidence. But yeah, there's argument on the record on that issue, and then after the result, if memory serves me, and I don't have the record in front of me either, but if memory serves me, I believe that there was a conversation among counsel, and then there was a conversation among counsel and the court, where it was determined that the proper next step would be for the parties to brief the issue so that everything could be before the trial court to consider before making its ruling that we're now here before your honors. You know, the attorney fee issue, I think counsel agrees, is not available to the plaintiff on a breach of contract claim. Certainly on a breach of contract claim that we haven't gotten to a level of bad faith or something there on the breach of contract, and as the only verdict that was entered was the breach of contract, clearly there can be no attorney fees. With respect to the fraud, since there's no damages, I don't think that claim can go through either. I think that those are the issues, and again, ultimately I think it does come down to there is a complete lack of evidence of any damages beyond those contractual damages. And when plaintiff made the determination to proceed on the contract claim, plaintiff dictated the damages and how they would be determined. Certainly a jury could have come back and said, no, we don't think there was an oral contract. Again, maybe the jury determines there was no meeting of the minds based on the testimony. And then the fraud claim would have been properly in front of the jury and could have been properly determined. That isn't what we have here. What we have is a jury verdict on that issue. Counsel has suggested to the panel that we know what the jury thought, and we can see by the reasonable amount of their $5,000 thing. That's not a number that is based on any evidence that was submitted. And the fact that a number is quote-unquote unreasonable or not unreasonable is not a basis for it being appropriate or not. It's a made-up number by a jury, perhaps in an effort to punish my client, perhaps any other number of things. We don't have the ability to go in and read the minds of the jurors to say to them, what did you mean by this? But we do have the ability to look at the record, and the record doesn't show us anything at all that $5,000 relates to. It is essentially a number that the jury came up with, who knows how, but the record, there's an absence in the record of any basis for that number because the jury came up with it. The number that's in the record is the $10,000 number, as evidenced by the receipts and the testimony of the plaintiff. That's the only number in the record. That's the only measure of damages. And when it was awarded on the breach of contract, that was the end of the discussion because no evidence was presented of any damages above and beyond that number relative to the dispute and the alleged agreement between the plaintiff and the defendants. So we think that, first of all, we think Floorcraft clearly supports the position that you cannot get the second recovery here. Secondly, there's no evidence of any damages beyond the contractual damages that were awarded. So with those two pieces, we think that the trial court's decision coupled with the jury's decision is appropriate. As to the fees, obviously, absent anything beyond the contract and the contractual damages, attorney fees wouldn't be appropriate, and we think as a result, the appeal should not be found well taken, that this court should affirm the decision of the trial judge as well as the jury's verdict for the contract damage claim.
Thank you.
Thank you.
We have a little over 4 minutes.
Thank you, Your Honor. First, I'd like to go to Judge Whitmore's question about the jury instructions. Here, the jury, without objection from appellee, was instructed, and this is on 306, 307 of the transcript, what they must find to find the fraud. And they must find to find the fraud damage caused by the representation or concealment of a fact. They must find that there was intent to mislead. They must find these actions that are separate and apart from purely not paying on a contract. So I think that those were the instructions that were given. The jury's verdict means they found those things existed. So I think we absolutely know what the jury was thinking here. And again, those instructions went back without objections. The only objections made by appellee that are on the record, the only discussions about a directed verdict that are on the record are about simply that there wasn't sufficient evidence to support the factual basis for these things. That was the objection to the instructions, that was the objection to going forward. In fact, the appellee specifically asked to bifurcate the issue of punitive damages. It never said that punitive damages weren't allowable here. It just argued that the facts didn't support them. I think that appellee also argues that you simply cannot have a tort claim once you make the decision to go forward on a breach of contract claim. And that's just not supported by the law. And in fact, that issue is specifically addressed in the In Re Updegraff case I cited. And it found that interpreting the economic loss rule in the way appellee argues would effectively eviscerate the viability of a fraud or a fraud in the inducement tort claim in Ohio. Because you always have, or often have, a breach of contract and those types of fraud claims. And to say that the two cannot exist would make those almost a nullity. So I think that it's just a misstatement of the law to say that the two cannot go forward. And this is not an issue of double recovery. What the trial court here did was not simply say you can't recover the compensatory damages on count 1 and count 2. What the trial court did was vacate not only the count 2 on the fraud, but vacate what is potentially tens of thousands of dollars on punitive damages. So this is not simply an issue of the trial court not allowing a double recovery, as appellee argues. The trial court went much farther than that. And I think that
the trial court actually overturned the verdict on count 2 and said that you didn't present any damages on it.
The trial court said that we could not go forward, that it overturned the verdict. Although it did I don't know that it's difficult, it's kind of confusing how the trial court did it, because in instructing the jury and then allowing it to go to the jury and denying the directed verdict to the jury, the trial court said again and again and again that you need to find damages here as a result of the fraudulent conduct. And it found that that should go to the jury because there was enough evidence to demonstrate that we have damages here because of the fraudulent conduct. So I think that the trial court may have confused the issue of economic damages with the economic loss rule. Again, you can have economic damages as a result of a tort claim. The economic loss rule prohibits going forward on a tort theory when you only have evidence of a breach of contract, when you don't have the extra things cited by Judge Schaefer, such as intent, such as knowing that you're going into it and not paying. That's what the economic loss rule is about. And I think that the trial court's opinion seems to conflate the two issues. I think that that it was improper. If there was an issue of double recovery, then maybe the appropriate thing to do was to allow him to just recover on count one, or as Headley seems to be arguing, to have let Mr. Whitaker choose what count he was going to go forward on. But that certainly wasn't permitted here.
Okay, we'll take the matter under advisement.
Thank you.
Both for your presentations to the court. The court will issue a written opinion, which will be sent to both sides, as well as will be released on our website.